Thank you very much. I'm also going to begin with two personal comments, if I may. The first, like Yoel, I too have to apologize that I will not be able to remain for the final lecture in the series. I apologize especially to Judge Mishnayot Ben Yanazeh, but I have to teach in Jerusalem. The second personal comment is some kind of a confession. As some of the people who are aware of my academic work will know, I've been pretty critical, one could say, of Israeli courts and of many aspects of the Israeli system. But the truth is, when I want to feel good about our system, I just have to listen to a lecture like this. Or when I very often, and to be quite honest, on another note, I happen to have been in the United States when the war started in Iraq. I was on sabbatical there. And once again, you just say, well, when you put these things in comparative context, perhaps sometimes I think I've been too harsh on our own system. But now let me get down to Jonathan's very, very interesting and for me very instructive paper, in which he certainly shows the tension between these two forms of so-called administration of justice. And I must say I am not an expert in the law of the United States. And therefore I cannot comment on the substance of the paper. But what I want to do is to take this paper as a starting point and to hold up the position as you describe it in your paper to the norms of what I understand of international law. And I want to try to expose the inherent difficulties that I see in the United States position, even if it's as it stands today after changes in the military commissions and involvement of the federal courts in some prosecutions and, as you describe it, in the habeas corpus positions. And I want to comment on a number of points. My first point is going to be which legal regime applies. Second of all, I'm going to relate to the whole issue of emergency measures in a country which didn't even bother to declare a state of emergency. The third issue I want to speak to the issue of fair trial issues, which are very, very important issues. And finally, the one thing which has always regarded me as a totally pernicious distinction in United States jurisprudence, and that is the distinction between citizens and non-citizens. Now, I don't think that Jonathan, knowing his record, is going to disagree with quite a lot of what I say. So my marks, I must stress, are not directed at Jonathan or at his paper, but more at the phenomena which he exposes so well, and I would say in his paper. So now let's start with the question of which legal regime. Well, we have two opposing legal regimes here. We have the criminal justice legal regime, which is fundamentally a law enforcement regime based on human rights standards, with the possibility that in certain circumstances a state could declare a state of emergency. But even then, and I want to stress it, I'll come back to it a bit later if I have some time, the possibilities of derogating from the right to fair trial, even in a state of emergency, are highly, highly limited. Or we have an armed conflict regime. And my fundamental problem here is that terrorism itself is not an armed conflict. And terrorism as such does not justify using the model of armed conflict. In order to justify using the model of armed conflict, one has to show that there is indeed an armed conflict. And the act of terrorism itself, which we want to react to, has a nexus to that armed conflict. And there seems to be, in my mind, in American views, and it's reflected in the paper, a total confusion on this notion. Just mention the term terrorism, and this already justifies using what is called a war model or a model of armed conflict. And I refer you all to a wonderful article which has just appeared, written by Jelena Pejic of the International Committee of the Red Cross, in a recent book called Terrorism, Counterterrorism, International Law and Practice, edited by Katja Samuel and Nigel White, in which she specifically addresses this question. that it's a fundamental misconception to say that I've got a war on terror so that every terrorist act can be regarded as some part of an armed conflict. So clearly, I mean, it is possible to argue, and certainly the United States is involved in an armed conflict, certainly in Afghanistan and probably in Pakistan, and it may be fighting there against Al-Qaeda, and so there's an armed conflict between Al-Qaeda and the United States, at least in Pakistan and Afghanistan. It doesn't seem to me that one can draw at any time a conclusion that any attack of any case of terrorist attack against United States interests in the United States or anywhere else is necessarily part of that armed conflict, and that I find very, very bothering. It's nothing that we in our system do. It's very, very clear that our courts are very aware of the distinction. If you just take the fundamental judgment of Justice Barak in the question of targeted killings, his whole judgment is based on which legal regime applies, and can I apply a regime of armed conflict, and what is the status of the people within that armed conflict. It's a problem. Second of all, I think that one has to make a clear distinction between the prosecution and preventive detention. And here we have to make, and that brings me to the second issue of emergencies. Because if you're not going to prosecute people, then you have at least two possibilities. The one possibility is, all right, it's the law of armed conflict, but then you have to show me that the people you want to detain can be detained under the law of armed conflict. And I don't have to go into it now, the very complicated notion of the United States that these people somehow fall between the cracks of all the Geneva Conventions, and the Geneva Conventions apply, which in my mind is a total misconception of the way the Geneva Conventions are supposed to work. But even assuming then that you're not going to resort to detention under one of the articles of the Geneva Convention, either prisoners of war, which the United States certainly is not prepared to admit that certainly Al-Qaeda people are covered by the Third Geneva Convention. In my mind, they would then be covered by the Fourth Geneva Convention, and you would have to show that imperative reasons of security demand the detention of each individual. But assume that you don't adopt that model. My problem then is, well, can a state justify preventive detention? Now in Israel we have preventive detention, and I'm not going to be the one who's going to be the advocate of preventive detention. There's a very good article about to appear now about Sherry Cribbs. I don't know if people have seen it, looking at how our system works. But at least from a legal point of view, number one, we've recognized that you cannot justify preventive detention unless you have a state of emergency. And when Israel joined the International Covenant on Civil and Political Rights, it submitted a declaration under Article 4 and said it's derogating from Article 9 in order to allow preventive detention. In the preventive detention law in Israel itself, it stated that that law will apply only when we have a state of emergency. Now, everybody here knows we have a problem. We've had a state of emergency now for how many? 60 years, so it becomes a bit formalistic. But I think the formalistic points have some kind of value to them. And the United States has a system of preventive detention, as you describe, without thinking that it has to meet the international standards as far as that goes. The Brits didn't act like that. Straight after 9/11, the first thing they did was declare a state of emergency, both under the ICCPR and under the European Convention, for this reason. The United States is a party to the ICCPR, but somehow it doesn't seem to occur to them that they have to comply with its provisions. Now let me get down to the fair trial, and here Jonathan has done an excellent job, and I think his main point, which he made in his talk, is that they seem to be far more concerned with getting convictions than with guaranteeing the right of fair trial. And clearly the right of fair trial, though, is guaranteed both under the law of war and under human rights law. You look at the Geneva Conventions, you look at fundamental guarantees, and one of the fundamental guarantees under customary international law, which applies in all situations of armed conflict, is that no one may be convicted or sentenced except pursuant to a fair trial affording all essential judicial guarantees. Now here I find you're in a bit of a bind in the United States, because it's clear that there are certain essential guarantees which are laid down first and foremost in Article 14 of the International Covenant on Civil and Political Rights, and according to accepted jurisprudence, these same guarantees apply under the Geneva Conventions today. A state may choose to have stronger guarantees. A state may say, you know what, this is not good enough for us to protect our defendants, we're going to do more than that. But once it's done that, it's shown that in its view, these are what are required for a fair trial. And what the state, in my mind, cannot do, and this is exactly what you describe in your paper, you just say these are the demands of fair trial under our system, but they don't apply to certain people, because, first of all, they happen to be non-citizens of the United States, and that brings me to the essential pernicious kind of distinction, which is something that I'm talking totally as a non-American looking from the outside. And I appreciate all the American doctrines of to whom the Constitution applies. But to be quite honest, as an international lawyer, the American Constitution does not bother me very much. What bothers me are international standards of human rights, which in my mind, I demand that they be applied in Israel, and they should be applied in the United States as well. And when I read the international kind of documents, especially the ICCPR, to which the United States is a party, I see that the only cases in which the citizenship of a person is relevant is in political rights, voting, and in the right possibly of a person to enter his or her own country. I don't see that when it comes down to fair trial, there can be or justified any distinction between the rights afforded to one person and the rights afforded to another person just because they happen to be American citizens. So I think that these are questions which, and once again, I want to say, in no way are they criticizing of you or your paper, but I felt I'd use the opportunity to say something which possibly I know a little bit about, because I don't know very much about the things that you wrote in about the paper, and that is universal human rights standards. Thank you very much.